Hello, hi. How's everybody doing tonight? It's Friday. We made it. We made it. We made it to the end of the week. Hopefully, you guys are having a good Friday evening. Hopefully, you have something special planned for this weekend because, it's supposed to be nice here in Ohio. Hopefully, it's nice where you guys are living. It was very nice here today. But if you're new to the channel or you're just coming back for yet another live, welcome, welcome, welcome. My name is Tanya or TitaniumBuilt, and we do talk all things true crime. And we pop in a little bit of here and there as well. So if you're over on the Unfiltered channel, that's the second channel that we have. So we're growing. We're a growing bunch. So if you're over there and you want to come chat over on the TitaniumBuilt channel, you can, because there'll probably be more people in this live chat. If not, I'll be over there to chat. So either way, I'm going to try to chat on both tonight. So we've got all the computers all set up. So we'll see how good this goes. Usually I forget about that one over there, that little guy. Actually, brighten it up a little bit, maybe move it up. That might help. Hey DM, hey Catherine, hey Karen, welcome in everybody. Hey Squeaky, hey Mary Beth. I saw people were in here talking before I even came in. I love that. That's my favorite. Hey Faith. Oh, Faith in You. I like that name. That's cute. Oh, and your doggy. Oh. I have mine behind me. Hey, Cheryl. Hey, Steph. I've got one over there in that corner and then one over here. And I need a pet cam. I have an extra webcam. I need to hook it up. I need to hook that up. Oh, did someone else? Did anyone else get hit by the hurricane that's going around? Just wreaking havoc. Well, there's a tornado, right? And a hurricane that's going on. Tornado and a hurricane. So the tornado, I believe, hit last night. I heard like North Carolina. It hit like a school. And Oklahoma heard was getting bad weather. Oh my. I did till my husband came home from work. Mary Beth, I know, and it's Friday. Just kidding. I'm just kidding. I'm like, oh, no, I'm just kidding. I'm getting Vincent to go out with me tomorrow. We're going to go do something. Hey, Crystal. I don't care what he says, and we'll make him go with me. Hey, Groovy Nikki. Welcome in, LB. Welcome in, everybody. Hey, Glowbug. It's good to see you guys. Okay, I'll get down to the bottom. Lenora, we're going to talk about one of our favorites tonight. Nash Native, welcome in. Hey, Dreamcatcher. Hey, Virginia. Hey, Lenora. Hey, Tony. Hey, Mystic Vertigo. So we're going to talk about Sarah Boone, the one, the only, the one and the only. Now, I thought, I don't know. I thought she knew a little bit about law, but apparently she doesn't know anything about law. And this is going to be messy. This is going to be a really messy trial. I wish I lived in Florida. I would go to this trial. Definitely. I wonder if they're like, wonder where the, I know that there's bad weather in Fort Myers, because I need to actually get hold of my aunt and uncle, make sure they okay. Because they live like 20 minutes from there. So that's where I usually fly into. So hopefully everybody's okay, and everybody that's had bad weather, hopefully it's the end of it, and you guys everyone's okay. As long as you guys are okay, you can always rebuy things. You can always, get that stuff back. Are you having a dream? Hey, Araya. Hey, Raya. Hey, Raya. She's like kind of barking a little bit. It's cute. Hey. 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 Okay. She's there. She's all right. She's cool. She's making the cutest noise. Renee, you like Fort Myers? I don't think I've ever been to Fort Myers Beach. I don't think I've been to the beach. They take me to all kinds of beaches, though. We went to, they live in Port Charlotte, and they've taken me like to beaches around there in their area. But they do have like saltwater pools. You guys whoever lives down there is lucky. Y'all are lucky. Sarah Boone, not so much. Sarah Boone, not so much. She's not so lucky. We got one walking around now. But are they good? Because I saw that there was a lot of water, and I was just like, woo. I wouldn't do good in a flood. No, no. I'm not a big fan of water. No, I would be terrified. But we get, we've had tornadoes here, so. But we'll get into our case that we're going to talk about tonight. Hey, leave her alone. This dog always has to start, doesn't she? She always has to start. It's always Mia. Mia's the troublemaker. Mia's the baby of the group. So she's been writing. So Sarah Boone's been writing letters to the judge. She's been doing this whole time since she's been incarcerated. She wrote to Judge Wooten when he was the judge, and now there is this new judge, and she's doing the same thing with him. And now she kind of has to because of her position. She's now pro se, so she's her own attorney. She's went through 8 prior attorneys to get her to this point. So it's not like this wasn't something that she knew couldn't be a possibility when she was running through them, calling them buffoons and, just telling them they couldn't do their job. So that's why they left. But she's been writing letters to the judge, and that's her form of communication right now because she can't call. And they have to have these motions hearings and bring her in because he can't call her back. And I don't really see him writing her a love letter, just bring her into court, just bring her on in here because she's just going to have a rebuttal. Of course, anytime that she can rebut, she's going to. So the other night she was on, let me see, where were we at? I wanted to make sure I'm doing the right ones. Okay. So the first hearing she had was on Monday, August the 5th. And she was pretty much telling the judge she doesn't want to do it. She don't want to be pro se anymore. It was like a 2-hour hearing. So instead of going over the full 2 hours, I have like a clip that will play for that hearing. And then we'll listen to the hearing that was today because she had a hearing today as well on 3 different motions. So the first one here that we're going to go over, it's going to be pretty much her asking the judge for legal advice, even though he can't give it to her, but he gives her a little bit of a definitions of things, she's asking some very like the questions she is asking, she should know the answer before you even go pro se. Like you shouldn't even, this woman needs a lawyer, but he ain't going to give it to her. He's not going to give it to her. He's like, nope, not today, not tomorrow, not any day. Like he's done, Hey, Doodlebug, I like your new picture with the little lips. Oh, this case will take months to represent herself. I don't know. I don't know how she's going to represent herself when she's asking, what is an objection? What does sustained mean? Like, honey, those are, if you don't know the smallest of the legal jargon, then you probably need a lawyer. But she's in here, she's doing her thing. She's, she's going to ask for a lawyer, but she's not going to get one.
2 days to prepare for trial.
So this is going to be her new, and this is going to be her new judge.
So in over 4 years, it comes down.
Sorry, this one's kind of low.
62 days.
I'm not going to answer that question.
Sarah Boone, the Florida woman accused of zipping her boyfriend up in a small suitcase and leaving him in there to suffocate, appeared in court Monday representing herself.
There it was. The shoes. Oh, right there. Okay. So you guys know I've been trying to tell you guys about the shoes, right? The shoes that are moved. Okay. So the suitcase is there. Do you see the rug, the striped rug? Do you see those flip-flops right there in the bottom corner? Because this is how calculated this woman is. I'm gonna tell you in a minute. Those shoes are like men's shoes, like men's sandals. You don't really get a good look this is like the best look that you get of them until she moves them. So after the suitcase is moved, remember how it gets moved and it's straight on the wall? Those shoes are thrown over by the suitcase. Almost like when she was sitting on the couch recording him, maybe she picked him up and she just threw the shoes over there. But I just wanted y'all to see the shoes. So here we go.
Small suitcase and leaving him in there to suffocate.
You can see them really good right there. Those look like men's sandals to me.
Appeared in court Monday representing herself. This after a judge ruled that her repeated clashes with public defenders means now she's on her own. We've got the biggest updates from Boone's latest appearance and what the court recently granted her as she tries to navigate going pro se. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber.
Who's in charge of the jail haircuts?
Sarah Boone may be making a name for herself as a difficult defendant. It's probably a kind way to say it. And what a day in court she just had. And we're going to get into that. But I got to give you some context on what's happening here. So Since her arrest in 2020 for the murder of her boyfriend, George Torres Jr., she has gone through 8 public defenders, 8 attorneys, with several of them stepping away from her case due to, quote, irreconcilable differences. And Boone has made no secret of her feelings about her attorneys. In her correspondence with the court, she has called various attorneys snotty, duds, buffoons. One attorney wrote in his motion to withdraw that, quote, no attorney can satisfy her. In June, the latest, Patricia Cashman, who has been described by the court as being widely known to be able and willing to deal with and manage difficult clients, she asked to withdraw. So what did Sarah Boone do? Well, I got to tell you, this is a first for me. I don't think I've ever seen anything like this happen because she put her creative skills to the test and she drafted, I'm not kidding you,
Look at her
a
smiling.
wanted ad.
Did you see her look at that camera and smirk? I did. I saw it.
If this story weren't so horrific, it would
she's loving the spotlight.
Almost be comical. Because in this ad, she says the candidate to be her attorney, what a great job that will be, should have, quote, original creativity, extraordinary expertise, and confident ingenuity. It reads, looking for a prosperous challenge? Ready for your close-up on national television? Are you zealous with a side of keen? Show the world who you are. So far, no
like
takers.
that?
Shocker, right? Shocker. Who I can't
Other than
imagine.
the
Not everybody
circus.
wants
Other than people at the circus, who talks like that?
to jump on this case. Now, Boone, she is charged in the second-degree murder of George out in Winter Park, Florida. This is north of Orlando. And according to police, she and George had been dating for several years when Boone admitted that she intentionally zipped George into the suitcase, claiming they had been drinking and playing a game of hide and seek. She says she went to bed forgetting he was in there, found him the next morning. The problem with that for her? The investigation uncovered a cell phone video allegedly recorded by Boone that shows her seemingly taunting George in the suitcase as he
She
begs
mad?
for help.
For everything you've done
There's
to
the
me.
shoes, see?
For everything you've done to me.
You see the shoes? Just keep your eye on them shoes because if I'm going to show you the suitcase moving in a minute. If they don't show it.
You.
Sarah.
You.
Sarah.
Stupid.
Sarah.
That's my name. Don't wear it up.
Honestly, it is so disturbing to watch and hear that, but it's going to be an incredibly powerful piece of evidence for the jury. Now,
If I was in that suitcase, I would have hawked out of that thing hearing those words. I saw someone put on somewhere today, why didn't he just learn how to use a zipper? I'm not even going to talk about the mechanics of that. But I mean, are you kidding? Do you think he didn't try? You think he didn't try everything? Like, I mean, you could see the guy, he was trying to control his breathing.
during her interrogation, Boone told the detectives that George was an alcoholic, that he had been abusive towards her.
Yeah, I'm
They both
looking it
had
up right now.
arrests on the record for domestic violence incidents, she claims. In fact, we looked up Sarah Boone and her legal history on truthfinder.com. That's our sponsor. It's one of the largest public record search services in the United
Truth Finder. Okay, whatever. Truth Finder. Okay, I have it now. I found it. So this suitcase, it's going to move. And I'll show you where the shoes. I don't know if the shoes are right there, but then like right when it's moved, but yeah, it is. Okay. So here's the suitcase. And there it's moved. And see the shoes are over there? She moved that suitcase and then she threw his shoes at him. She threw his shoes. Tossed them right over there. Now that's cold-hearted too. Now that's just add that to the list of things, you know. Insta Justice, True Crime and Trials. Oh, I like your name. I like that. 8 attorneys couldn't handle her. Well, she was calling them little words like buffoons. Like, I mean, if that's going to get to you, you know what I mean? Like, I'm sure you've been called worse, sir. Like the last lawyer was, I mean, I think he was just ready to get out. Like he was like, they all left. I'm ready to leave. But yeah, so I just wanted to show you that because I never noticed that until the other day.
United States. And by the way,
Let's fast forward through this because we don't need this in our life.
see sidebar. But going back to Sarah Boone, Boone insisted that while she might have made a
You can see her smile at the. I'm sorry. She's trying to be cute.
horrible sidebar, but going back to Sarah Boone, Boone insisted that while she might have made a horrible mistake when it came to George, she didn't kill him on purpose.
Nobody knew George better than I did. I say that I knew George better than himself. And I tried in every way, shape, and form. Ask everyone. I helped him. I took care of him. I missed him a lot, and I didn't even sleep last night. I miss him a lot.
I mean, is there any chance it got to be too much for you and you couldn't handle taking care of him and
I never stopped.
trying to...
I never
Okay.
stopped. That's what I'm here for. I never stopped.
You're there because they asked you to come answer some questions. Boom.
I'm here now because I'm still trying to help him.
But why is he saying I can't breathe, and why is he pushing on it as if he can't get out?
Yeah.
And it doesn't show a hole.
There's no hole. There's no fingers. I don't see his fingers. There's no hole.
I don't know what you want me to tell you. Like, I don't know.
By the way, since 2020, Boone has been locked up in jail, and despite being there for 4 years, Boone doesn't appear to have had a hearing on whether she can be let out on bond. She's previously suggested that even though she expects that the bond would be high,
Someone should
her
get
quote,
fired from the
fans
salon.
would be willing to donate to the cause. So with all that, now let's talk about what happened on Monday, this
Harry.
hearing. So Judge Michael Kranick addressed 4 motions that Boone filed via mail, which we're also going to be able to take a look at. Now, in her loopy handwriting, the first set of correspondence with the court is titled
I have
Motion
some to read you
Requesting
too.
Immediate Relief to the Defendant by Appointing Effective Standby Counsel to Aid and Support in Preparation for Her Criminal Case for Trial. Now, Boone names herself as a pro se indigent defendant, indigent meaning she can't pay for her own outside counsel. That's why the court.
I just thought of something. She has a laptop, right? 8 hours a day, she has the laptop. Why is she handwriting motions when she could be typing them up? Surely, I mean, it takes way longer and it hurts your hands to be writing all of these out.
Court had granted her public defenders, so she's representing herself pro se. Now, she goes on to list several legal precedents that grant her the right to standby counsel and says, quote, by the court rejecting professional, educated, experienced aid and assistance of effective standby counsel to and for the defendant in preparation and production of her rightful defense, results may be adverse from the unfair, disadvantaged, oppressed circumstances to properly thrive in her forced position by the court of pro se attorney and representation of self. Wow, that's a mouthful. So on the one hand, she apparently hasn't liked or worked well with any of her public defenders. And remember, there's 8 of them. But on the other hand, she wants to know why the court is forcing her to go pro se. Well, also present in court on Monday was a member of the Justice Administrative Commission, or JAC, Christian Lake. And he pointed out that standby counsel won't actually be there to help Boone along the way.
I think Ms. Boone misunderstands the role of standby counsel. Standby counsel is not co-counsel or assistant counsel to a defendant. Standby counsel is there for when, in the situation where a pro se defendant who is elected to represent herself decides at some point they want a lawyer, that allows the court to put a lawyer back into play at that point in time. In other words, it's a safety mechanism so that if a defendant who is decided to represent themselves decides at some point they do no longer want to represent themselves, the court has a lawyer already in place so that the progress is not delayed. It is not an assistant or a co-counsel. It is someone whose role is consenting not to get involved until the defendant says, I no longer want to represent myself.
Ma'am, the court's had the opportunity to review the case law on this issue. There is no constitutional right to standby counsel as decided by Paul versus State 152.
See, I thought standby counsel was just that. I thought they were standby if you needed them. Like standby, like if you had a question. But it makes sense. Because I would take forever if you had, if you had someone you could help you, like you could be like, well, okay, answer this, answer that, answer this, answer that. But he's saying no, like you either, like you say, forfeiture your pro se and get rid of that, and you stick with this one lawyer, whoever it is.
To Southern 3rd 635 at pinpoint 641 by the Florida 4th District Court of Appeal in 2014, citing to the Florida Supreme Court case in Jones v. State 449 Southern 2nd 253 at pinpoint 258 from 1984. As the court has determined that you have forfeited and alternatively waived by your conduct the right to court-appointed counsel, the court is not required to appoint standby counsel. That's Brown v. State, 45 Southern 3rd, 110 at pinpoint 114 through 115, Florida 1st DCA 2010, citing to, again, Jones v. State by the Florida Supreme Court in 1984. There is no Sixth Amendment right to simultaneously proceeding pro se with legal representation by the Florida Supreme Court in 2009 in Shepherd versus State, 17 Southern 3rd, 275 and 279. For the reasons that the court identified in its 16-page order previously entered, your request for standby counsel is denied.
So it's denied. You don't even get that
Do you have
option
any other
done.
questions, ma'am, as to the court's rulings this morning?
Is that me? Is that what I think he's saying? He's saying, sorry, you're not even, no, we're not doing it. We're not even going backwards. You're your own damn lawyer. Court is going on October 7th. Okay.
First of all, I do not forfeit my rights.
First of all,
That was your judgment. And also, I feel that I should have had some type of evidentiary hearing prior to your decision. So I could have better explained myself and you could have had a better understanding. So by you denying my standby counsel, which thank you to him for explaining to me what specifically it is, I don't want to be pro se any longer. So I didn't want to be pro se in the first place. And again, you, in my opinion, unlawfully denied me or didn't even suggest an evidentiary hearing in order for me to avoid or try to go about a solution or remedy so you would understand. So I don't know if it's me either wasting your time or anybody else's time, if it's even an opportunity or if it's just something that is denied, period.
The judge let Sarah Boone know that this trial is scheduled to begin October 7th and that the court will be extending the time frame for trial from 2 weeks to 3 weeks. It seems that Boone will have a chance to review the evidence that the state wants to admit next month, but the defendant took issue with how quickly things would be moving and how much time she would have to prepare.
Forgive me. So today being August 5th, I'm supposed to expeditiously complete my case that in every way, shape, and form by September 26th in order to go to trial for October 7th.
The dates are what the dates are. September 26th is the trial case management date, and October 7th is the trial date.
So by me not even seeing my discovery yet 2 days and only being restricted to a laptop from 8 to 4 and not having my hard copy evidence.
8 to
You
4.
have 62 days to prepare for trial. Not
62 days to prepare for trial. Oh, I like them. I like them.
And you're going to get your discovery today.
Give her the hard copies.
Wow. So in
Wow.
4 years, it comes down to me representing myself in 62 days.
4 years and 62 days or whatever. You know what I mean? Sarah Boone, you've been needing to go to trial for 4 years now, babe. 4 years. Next February, we're going to be on 5, right? we're past 4. We're way past 4. So you knew that you had this coming up. And it should have been on you to be prepared for it. Now, you know what they have for discovery because it's your phone. You know that's the major piece of evidence that you need to try to figure out how to get around. I'm not even a lawyer or her lawyer or in her position, and I know that's the biggest piece of evidence. That's the hurdle she needs to climb. And then she needs to make Jorge seem like he's this bad guy because he got arrested 3 more times than she did. For DV. That's really what it comes down to. They've both been arrested for DV. He was arrested a couple more times. To me, they're both bad. You know what I mean? They're bad together. But she's going to try to play that card. That's her
I'm not
defense.
going to answer that question.
Am I supposed to?
What now we're addressing, ma'am, is September 17th,
Right.
the deadline, which is 2 weeks after having the physical view of any of the physical evidence. It sounds like Mr. J is going to try to meet with you pretty promptly regarding the digital evidence. So you'll have plenty of time to review that in 2 weeks at a minimum, or 2 weeks at most, rather, to lodge any objections to the physical evidence.
I understand. I just don't understand how to file objections.
I cannot answer that for you. That would be me providing you legal advice, which I'm prohibited from doing. All I can tell you is that if you have objections to any of the exhibits that the state may seek to move into evidence, you will have to lodge those objections by the close of business on September 17th.
I don't know what I'm doing. I don't know. I do not know what I'm doing. So I'm trying to learn as I go.
Well,
Which
we
is why
knew
I'm
that.
grateful for everyone's patience, but at the same time, though, for me to accept this date and then not be able to meet it, what happens when that happens, if it should happen?
I can't answer that
It's
question.
gonna happen.
Again, that would be me providing you legal advice as to what to do if something happens. I simply cannot answer that question. I'm not allowed to.
Well, she admits that she doesn't know what she's doing. Now, the judge said repeatedly during the hearing that the reasons why Boone forfeited her right to counsel, they were laid out in a document already filed, and that was sent to her. That 16-page order lays out all the problems that Boone has had with her attorneys and all the times those public defenders have asked to withdraw from the case. And he then cited precedent for why a defendant might have to go pro se. Well, in her letter, Sarah Boone talked about her rights. And for example, she writes, quote, waiver of counsel is a criminal defendant's refusal of counsel at any stage in the criminal process. I have never refused it. It is made by a person with full capacity, unprepared, that is knowing, involuntary, forced, and that clearly and unequivocally rejects representation of assistance by an attorney at law during the pending proceedings. And Boone is continually saying that she was forced by the court to represent herself. But here's the problem. Here's a little legal primer here. Yes, criminal defendants have a right to counsel. It is in the 6th Amendment. It says that in all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense. But in terms of a right to counsel, while a defendant can certainly have a choice at times on who he or she wants to represent them, this is not an absolute right. If the defendant engages in misconduct, they can forfeit that right to counsel. You can't engage in conduct, for example, that deliberately delays the trial or obstructs the proceedings. And here, this is what has happened. Boone has forfeited her right to counsel. The judge has written, quote, forfeiture is an extreme measure that flows from the defendant's abuse or manipulation of and results in the defendant being required to represent himself even though he has not waived counsel and may still want legal representation. The judge continued, it has become apparent to the court the defendant will not permit herself to be represented by anyone. Now, another issue that the court addressed is how Boone can represent herself when she's currently incarcerated and may not have access to everything she needs. In her letter, she points out that she, quote, does not have access to a computer and does not have access to the internet.
She does.
Defendant does not have access to
Well, not the internet
organization
part.
supplies or production equipment. Then in parentheses, it says copier, printer, etc. Defendant does not have access to a meeting place for privacy and case review preparation. Boone even listed examples of some of the hardships she's
She's got a bunk. She's fine.
facing.
She's got
First,
a quiet
the
spot.
defendant has not received from the court to date of this motion any of her promised discovery or case-related materials submitted by former attorney to the court during the unannounced hearing on 6/28/24. Boone has contended that she didn't even know her last court hearing was happening and was unexpectedly dragged to the courthouse. So that means, of course, she also hasn't had a chance to review that discovery. She reiterated these concerns to Judge Kranick, and let's see how that went.
I'm going to go with to be determined because I just explained also, please, that I do not have access to a regular phone. I need to locate anyone. I need to do research. I don't know if I have internet access to anyone. I don't have a phone book. There's no way that I know how to do any of this without essentials and
Probably should have thought of that before we put Jorge in the suitcase and you zipped his ass up. And then you recorded it. And then you went to bed. And then you went downstairs and you called your ex-husband the next day before calling police. Maybe you should have thought of all that before you needed your essentials, your school supplies. You're not going back to school because it's August, Sarah Boone. You're going to court.
fundamental
You need prayers, not a pencil. You know what I mean? You need a lot of them.
equipment in order for me to be able to provide you with those answers. I cannot promise anything because I do not know how I would be able to do any of that at this moment. I would like please to propose your understanding of a meeting that I would like to have with the captain, so I can see if I
The
can
captain,
have access to a regular phone, if I can have access to an internet. Right now, I have a tablet that is used for text messaging and movies and the law library that I utilize. I don't have.
you can text message in jail now? What? Hold on a second. Really? Did I hear her correctly? You can text in jail.
Have access to an internet. Right now, I have a tablet that is used for text messaging and movies and the law library that I utilize.
Are you freaking kidding me? Why are I'm really shocked. I'm shook, y'all. I knew they gave him like iPads and stuff. And I remember like Alec Murdoch, remember his no nipple picture he took? We were wondering where his nipples went. Like it was it was a bad picture. I knew they had those things, but I didn't realize that you could be like just texting. Like, so every day they come and they bring you your iPad and then you can, oh my, you can even do the emojis and everything. You get the big print, you get the big font. Wow.
I don't have access to the phone. I don't have access to the internet.
You can certainly have those conversations with the jail representatives. But ma'am, we were on notice today to address those deadlines, and I cannot set a to be determined deadline at this time. I understand that there's been some delays with regard to the discovery. As I told you at the last hearing, we're moving as expeditiously as possible to get you that, and it took some time for that process to be created. That process is going to start today. Mr. Lane's here. Representative from the Orange County Jail will be here. That handoff will take place. You'll have access to that laptop with all the information today.
All right, I just want to highlight some other interesting tidbits from Sarah Boone's correspondence with the court, because in another letter, she makes out all these other requests. For example, it says, comes now Sarah Boone, pro se indigent defendant, respectfully requests from this court the reservation of proposed costs to acquire investigator for defense's defense in trial. She writes out investigator, TBD, meaning to be determined, total amount requesting, TBD, how to calculate, unknown by defendant, reason, no discovery or case materials provided to defendant from the judge. And she reiterates a lot of what she said in the first correspondence to the court, mainly that she's been forced to represent herself and that the court is hiding information from her. Boone also requests money to pay for expert witnesses, saying that once again, the costs are to be determined. She filed another motion requesting reservation of any and all costs proposed to be incurred to acquire all witnesses needed for the defendant's defense in trial of her criminal case.
Wasn't she having trouble getting an expert to testify for her?
She also wants to be able to depose witnesses.
Uh-oh.
So what was the response to all these requests?
Just
Well,
something-
the Justice Administrative Commission filed a response, and it said, quote, as for costs to take deposition, the defendant is authorized to incur costs to take depositions for those deposition authorized under the Florida Rules of Criminal Procedures. As for service of process, service must be through the sheriff unless the sheriff is unable or unavailable to provide service of process. In those instances where private service of process is necessary, a separate motion to incur costs for a private process server will be required. The sheriff must be used to serve in-county law enforcement. The document goes on to say that private investigators cannot be paid more than the rate of $50 per hour and that they have to be licensed in Florida. Well, what about
$50 an hour? That's it?
witnesses to testify in Boone's defense? The response says,
Nobody.
based on JAC's records, the court previously approved $3,000 at a rate of $200 per hour for a defense mental health expert. JAC does not object to the court continuing this authorization now that the defendant is representing herself. As to other requests for other experts, the defendant will need to file an appropriate motion delineating the following. 1, identify or type of expert, 2, amount authorized cap for the expert services, and 3, rates authorized for the expert services. As for just regular witnesses, the commission says Boone would need to submit a more detailed motion about why there would be costs associated with each of them. This is why you have an attorney represent you. This is why it gets complicated, very simply, okay? Well,
Right.
for now, Boone's trial is scheduled to begin in October, and Judge Kranick has said, he's indicated, that this trial will not be delayed any further unless there is extraordinary good cause to do so. And that doesn't mean if Sarah Boone decides to retain new counsel. This trial will move forward at the same pace. Later this week, a hearing is scheduled to determine if Sarah Boone will be allowed to be unshackled during trial. We will see what happens, and we will continue to follow this case for you right here on Sidebar.
That's crazy. 15 an hour in Indiana. Oh my, I was reading, I was typing it out, and I was like, I'll just say it. Because, oh my Lord, that's crazy. 15 an hour. What are they going to do with that? That you can work at Chick-fil-A for 15 an hour now. You know, you can work like anywhere. Like that's like the minimum wage. Oh my gosh. So I can't remember if it was, I want to say it was $3.50 an hour that for Miss Dorothy for Letitia Stauch's trial, her expert, because I think on when she was on the stand, she's like, yeah, I'm getting $3.50 an hour. And I think they were corrected her actually. And they were like, no, you're getting $300 an hour. Like, and I was like, oh, damn, put her in her place. But she's going to need somebody that she's going to need someone that knows how to do phones. And I don't know how you're going to get around a video. I don't know how you get around that. Because the data is in there when it was taken, what time it was filmed. You know, you can't say, well, that was from the other night. He got out of that suitcase just fine that night. You know, like you can't go backwards like that. But, you know, and we all saw you the next day, Sarah. You were really hungover, girl. You called your ex-husband before you called the cops. That poor lady, that poor officer, she had hard as gold. She was like, I'm trying to get you a water. She was trying to just like get Sarah out of her life. Like she was just like, please, honey. So she did have another hearing. Sarah did. It was today actually. So we're going to listen to that. And I'll go over her newest letter before we do that. Her newest letter to the court it went in for this video. So she's handwriting these. I don't know why she don't just use the laptop or even the iPad. I mean, I'm sure you can get little notes on there or something, you know, like notes. I'm sure that has that app on there. If you can text somebody, I'm sure you can get like a note app on there. Just take some notes. But I'm glad her handwriting is nice. We can at least read it. The first few letters I couldn't read very well. So this is just all about the court up at the top. Just like if you were to read, you know, any legal document. I wonder whose documents she's taking and like reading them and then, you know, putting them into Word format for her own document. Motion for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed to function equally and comfortably while utilizing the courtroom. So basically, she wants to be hands-free. Comes now Sarah Boone, pro se indigent defendant, respectfully request from the court to be unshackled, uncuffed, and allowed reasonable freedom and movement to function accordingly, equally, and comfortably while utilizing the courtroom. The defendant must be able to write, reach, turn pages, pick up objects, open documents, pass information, utilize laptop, all normal movement of the defendant's hands, and as a whole to freely, properly, successfully accomplish any task needed for. Prior to entrance of the courtroom, the defendant is thoroughly inspected and searched, is under direct surveillance of the judge, all judicial assistants, news cameras, and their operators, photographers, general public, witness of the court, as well as vigilante armed deputies, also in attendance, greatly diminishing all possible risk of flight or harm by the defendant while unshackled and unhandcuffed. This is what she did last time. Her handwriting started getting slowly worse as I would read it. It's probably just my eyes, though. The defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which will greatly enhance the productivity and progress for the defendant and the compilation of her defense in her criminal case in preparation for trial. The court's overall perspective, and you better hurry up and get prepared for trial because trial's almost here, baby girl. The court's overall perspective and correct understanding of this performance obstacle for the defendant is also requested, respectfully seeing her good faith, determined efforts to thrive and achieve in her criminal case rightfully, properly, and fairly. Wherefore, Sarah Boone, pro se indigent defendant, respectfully requests to this honor able court in conclusion to be unshackled, unhandcuffed, and allowed reasonable freedom and movement to function equally, accordingly, and comfortably in the courtroom. I would not be writing out all this. I'd be like, Judge, take the shackles off because I need to be able to work. As the, if I was writing it, I would not be wasting my hand and the court's time. I would not be wasting the court's time by reading repetitively over and over again. We're reading the same thing. But it sounds like a legal document. I mean, she definitely copied off somebody. Under the authority of section, there's the Idaho, or the, not Idaho, I'm used to reading Idaho documents, Florida section, statute and state, and I don't know if those are correct, but that's what they say. The defendant makes the following oath under the penalties of perjury. I declare under penalties of perjury that I have read the foregoing document and the facts and matters stated are true. You wrote it. You don't need to write that. You could have wrote, love ya, Sarah Boone. Remember the lady that was talking about the O's? She said that, like, the handwriting lady. She said if you write your O's and they're kind of sloppy looking, it means like your thoughts are like sloppy or like all over the place. And if you write them like perfect, that means like you're centered. Mine were perfect O's, and that's a lie. I'm like, that's a lie. So let's watch old Sarah in action. But before we do that, I'll read you a little bit of what you're gonna what you'll be watching. We're gonna watch this together. So Sarah Boone returned to court. This was today. This came out this morning. This article did. Boone is charged with second-degree murder of her boyfriend Jorge Torres, who was found zipped inside a suitcase after the couple had been drinking. After 8 attorneys withdrew from her case, Judge Michael Kranick ordered Boone to represent herself, finding she had forfeited her right to an attorney. Representing herself, Boone has struggled to gain access to evidence in her case and filed a handwritten motion this week asking for hard copies of discovery evidence to be provided to her. Much of the discovery has been handed over on a USB drive, which can only be used on a computer, and Boone only has access to electronics during specific hours in jail. Kranick granted Boone's motion, which means she will be able to review the evidence on paper. On Friday, Boone also argued that her motion to be unshackled in court, specifying to the judge that she wanted to have her hands free during pretrial hearings, but wanted to be fully unrestrained during her trial. Orange County Sheriff Deputy Gavin Lotan testified at the hearing, saying he did not believe that Boone should be unshackled. She probably shouldn't be. What about those like leg things? They can put those on you, can't they? We're like shock ship. Based on her current charge of second-degree M, she also has previous domestic arrest for battery strangulation. Remember when she was chasing Jorge up the stairs trying to strangle him from behind? She was so mad. Yeah, back in 2018. She has 3 separate incidents at the jail for noncompliance where she was told to attend her court hearings, her scheduled court hearings, and she refused to do so. Even though corrections officers told her she could get charged or be charged with contempt of court, she still refused to attend those hearings. When you combine all of that, it shows a propensity for violence and not wanting to follow lawful commands and orders from law enforcement personnel. I'm just asking to sit here unhandcuffed so I can write without taking skin off my wrist and being extremely uncomfortable, Boone told the judge. Boone questioned whether she had missed any court dates and challenged the information that Lotan said, saying, I've never missed a court date in the almost 5 years that I've been here. I never argued. I've never hesitated. You've been in jail the whole time. So of course you're there. All they had to do is come get you from the jail, Sarah. It's not like you're at home and you came out of your way to come to court. She's been like in the whole 5 years, and it's not been 5 years yet, but it's getting there. Judge Kranick ruled that Boone will not be handcuffed for future pretrial hearings, but will be in leg shackles. For the trial, she will have neither shackles nor handcuffs, but will be fitted with a stun cuff. Courthouse Deputy Chad Barnett testified in court that the wireless electric cuff is secure to the defendant's leg and can discharge 50,000 volts of electricity, causing the person to fall. A deputy will be assigned to monitor Boone and will control the cuff. Yeah, he said it's a 2-part process too. So like you have to really mean to do it. Like, hit the button to shock her. So Boone is due back in court August 14th. And they're going to discuss, it says, how she can access some more evidence in her case. Yay. So, I mean, I could see her wilding out and running out of the courthouse. I could see that. I could see anything happening with this trial. I mean, anything with this. Oh yeah, peanut butter complaints. I hope that's all they give her solo to eat. I hope that's all she eats. I never want to listen to her voice again. I never want to hear it. I never want to hear it. I never want to hear it. When that trial was done, I was so done with that lady. I was like, I'm done with you. She's a bad seed. I was going to play this on YouTube actually, because I think it'll play a little bit better. But this is Sarah going into court today. I'm going to put it at 1.25. I don't think it'll be too fast. We'll see. If it is too fast, we'll slow it back down. Oh, it looks like we've got a new officer there too. So this guy was here the last 2 hearings. Before it was a woman. Let me see let me get you guys on the right page. There we go. There we go. Okay. Thank you guys for being here tonight. I do appreciate it. I really, really do. It's Friday night. You guys can be doing anything you want, but you're hanging out with me. We're talking Sarah Boone. So don't forget to subscribe to the channel if you haven't done so already, and hit the like button on the video if you haven't done so we can get onto the algorithm. Get Sarah's name out there. She wants this attention. Let's give it to her, She's smiling at the camera. And she was so mad when the news knew before her that she had a court date. She was so mad. I'd been mad though too. Sorry, that was really loud. Okay, I'll take that down and I'll slowly put it up.
Ma'am, good morning. Raise your right hand. Madam Clerk will swear you in.
I swear over the testimony.
All right, ma'am, good morning, rather. Could you state your full name and date of birth for the record for me? Okay.
Her sound should get better.
Had a hearing this Monday on August the 5th. The court had entered a scheduling order and notice of hearings. Ma'am, that was sent to you by way of mail. Did you receive that?
I did yesterday.
Okay, all right. I know that you had brought up concerns regarding mailing, and I just wanted to go through the historics with regards to the mailing. As you may recall, back on June 28th, we had a hearing where I granted
Sorry, I was trying to go off the mute. So basically, like today, what she's going to be in here for is they're going to talk about she's going to address the judge about not knowing where her address is, like to where to send her paperwork and stuff, which I don't know why they wouldn't know the jail address. Okay. But they're going to go over that. So that's something that she's going to win today, because obviously that's a motion she's going to win. Freedom of movement was the next one that they're going to go over. And then that's going to be just her, walking freely throughout the courtroom. And then the other one was the hard copies that she wants. She wants the hard copies of everything on the USB drive. So I just wanted to give you a little bit more before we started.
Ms. Cushman's motion to withdraw and addressed your forfeiture, alternatively a waiver to counsel. You were hand-delivered a copy of that order. On May 25, we had a hearing and an order was entered and a notice of hearing was set. That order was hand-delivered to you. Thereafter, there was an order setting hearing that was entered on July 29. That order rather, was sent to you at P.O. Box 9109, Seminole, Florida 33775, which is the Orange County Corrections Department mail address for general inmate mail. That was remedied the next day. On July 30th, a certificate of service was entered to the appropriate address, identifying you, your inmate number, FDC-B4, P.O. Box 4970, Orlando, Florida 32802, which is the address that you had placed in your motion and your notice. That certificate of service included the notice of filing of the memorandum from the Orange County Corrections Department, Security Operations, and there was also a certificate of service providing you the Justice Administrative Commission's response to motion seeking due process costs. The next mailings was a notice of mailing of documents by your former attorney, Patricia Cashman, which was the transcripts of depositions of detectives Chelsea Copsell and Scott Lowen, which were taken on May 7th, 2024. That was e-filed on August the 1st, 2024, and mailed to you with addressed to you, your inmate number, FDC Dorm B, PO Box 4970, I apologize, PO Box 4970, Orlando, Florida. Did you receive those deposition transcripts?
I did.
Okay. Then the notice of delivery, would you recall when you received those transcripts?
Everything that you are stating was received on Monday.
The 5th.
Correct.
Okay. The next was a notice of delivery of digital copies of documents that was e-filed by your former attorney, Patricia Cashman, on August 1, 2024, which provided the transcripts of depositions of detectives Chelsea Copsell and Scott Lowen taken May 7, 2024 to Billy Lane on August 1st. And that was mailed to you at the same address. We've been addressing PO Box 4970 on August 1. Did you receive that notice?
I'm sorry, what was that for?
Notice of delivery of digital copies of documents, which reflected the deposition transcripts of the detectives I just identified to Mr. Lane.
To be honest with you, I don't know. It was a lump sum of a giant amount of paperwork, and I haven't gone through it yet.
Okay.
They had me sign about 4 or 5 different documents, so.
Okay.
For receipt.
And the last was a certificate of service that was just e-filed on May the 5th, which was provided to you as well on August the 5th. It was provided to you on August 5th at the PO Box we've identified by way of U.S. mail, which was a copy of the order authorizing the defense to incur costs for private investigator and the scheduling order and notice of hearings entered August 5, 2024. Have you received both of those?
I did, and I had questions on that, please, whenever.
In just a moment, ma'am. So I know that there was a concern with regard to mailing and things purported.
Yeah, why would it be? I'm wondering why we would go into a PO box.
Timely provided to you. There was only one order, the order of July 29th, which was sent to the general mail delivery. And that was remedied the exact next day on July 30th. So that clerical error as to the wrong address was remedied one day after the original order was sent out on July the 29th. I just wanted to put that on the record and again, identify for you, ma'am, that nothing's being withheld from you and everything is being timely served to you as required. Now, you had questions about the JAC order. I will revisit those in just a moment. I've got a sticky with regard to that.
And I was going to say, please, if I may, about the address. There were 2 or 3 different documents that were uploaded to the tablet. So those 3 documents, without knowing specifically which ones they are, those were also sent to PO Box 9101.
I don't know what you're talking about.
You were talking about supposedly just one document that was mailed to the incorrect address. It was more than one.
That's not correct. Court scoured the court file this morning, ma'am. The court has not filed anything other than what I've identified since that June 28th order where you were representing yourself pro se. So that is incorrect.
Is it something that I need to record and bring back, or is it that big of a deal?
I can't answer that question. That may call for me providing you legal advice.
Okay.
But I can't
She's pretty much calling him a liar.
tell you that other than the July 29th order, which was remedied the next day, everything has been sent to the appropriate legal mail address as provided by the Orange County Jail. We've had this hearing today to address a couple of things based on the scheduling order and notice of hearing that was entered August 5. The first was the digital evidence issue. I've been advised, I think through Mr. Lane, who I do see in the courtroom. Mr. Lane, if you could come on up, sir, so Madam Clerk can swear you in.
Please swear or affirm the testimony you should give shall be the truth, the whole truth, and nothing but the truth, so help you God.
All right, Mr. Lane, good morning, sir. Can you state your full name and your affiliation with Prison Break Investigations, please?
Billy Lane, Chief Investigator, Owner, Prison Break Investigations.
Okay. I understand part of the order from Monday was regarding the state's digital evidence. I understand that may have been provided on a USB drive to you, Mr. Lane. I want to hear from the state with regard to that first. So either Mr. J or Mr. Cacciatore.
Yes, Your Honor. We have tendered to Mr. Lane
Oh, man.
a copy of.
I didn't even think about that. She has a kid. Oh, I want, and people saw his dad on the body cam and was like, hey, that looks like, what's his name's dad, Brian? Because that's his name, ex-husband Brian.
Our the exhibit list with our
well, hey, stranger. I like your name. That's
expected items of evidence that will be received, along with expected witnesses that, to be called at the trial. A copy of that was provided on the USB with the exhibits, the witness list, also proposed jury instructions and a stipulation as to victim ID for her review as well.
Okay. And when was that provided to Mr. Lane?
Just now.
Okay. All right. The witness and exhibit list that is included on that USB, do you have hard copies?
I do, Your Honor. I would like to file them in open court.
That was going to be my next question. Okay.
And I have a copy for defense.
Okay, very good. Debbie Bruce, if we can get the copy of the witness list and the exhibits and take that from Mr. Lane and provide it to Ms. Boone.
In your honor, the state's position is that given that our exhibit list contains within it a witness list as well, we would ask that that document be sealed the way the witness lists are routinely sealed. A copy of that request to seal is there with the notice of the witness list on the initial page before our notice of the exhibit list.
What I have in front of me is the notice of provision of witness list, and then the notice of expected evidence and witnesses of trial. I don't have an order or.
It wouldn't be an order. It would just be that first document you read, reference to notice of provision of witness list.
Got it. Okay, thank you. All right. Anything else with regard to the expected evidence and digital evidence?
No.
Okay, so just for my own understanding, there are 9 files on the USB drive that are digital in nature. Is that correct?
Yes.
Okay, all right. And those are all on the USB drive that is going to be provided to Ms. Boone?
Yes, they're broken down by folders.
And the folders, are the names of the folders, do they match the names in the digital evidence list?
They roughly match. I believe that on there may be some slight change of terminology from, I believe, files found on iPhone as opposed to Suitcase, videos, and still shot.
Okay, all right. State, anything else to add with regard to the digital evidence?
No, I also have a copy of the thumb drive as well that Mr. Lane has had an opportunity to copy for his client that I can tender to either tend it to Mr. Lane to tender to his client.
Is that different that we've already given him?
He had an opportunity to copy it, but this would be their copies are retained.
Okay, all right. So you can go ahead and provide that. Do you want to mark that as an exhibit for the purposes of the hearing? I guess not, since it's going to be transferred directly to Mr. Lane.
Correct.
Okay, all right. You can go ahead and give that to Mr. Lane. All right. Ma'am, or Mr. Castori, any other questions? Anything else you want to bring to my attention with regard to the digital evidence?
No, yeah.
Okay, ma'am, have you had the opportunity to review the notice of expected evidence and witnesses at trial document that was just provided to the court and yourself this morning?
I did.
Okay, do you have any questions with regard to the digital evidence, which are paragraphs 1 through 9 on the first and second pages of the notice?
I don't know what the majority of them are. Is this part of the evidence that was supplied to me on all of the USB drives that was supplied also?
Yes, this is a pared down. All of the items referenced in our notice and provided on the USB have already been previously disclosed and given to defense.
Okay. Any other questions? Yes.
Yes, on the USB drives for the laptop, it's not compatible with the USB drives for some of the files. So I cannot open a majority of what are on both of the USB drives.
What do you mean you cannot open a majority? What can you not open?
I don't know specifically which files. I know that some of them come up as videos, some of them come up as JPEG, some of them come up as different formats, but there's an entire page of multiple icons that come up, and every time I try to open one, it won't let me review it.
Okay,
so I don't
what
know.
does it say?
I don't know. I moved on from that to try to go to other programs, so I don't know. I figured it would be something that I might be able to speak to Billy about when he came to see me early next week. So, but I'm just stating to the court now that's one of the problems that I'm having with the laptop.
But you said it's a majority, but you can't identify specifics for me. That's what I'm trying to figure out. What is it that you're not able to look at?
It doesn't identify what they are because of the amount. When I click on a particular file, there's a file inside of a file inside of a file. So when I try to open one of the files, all these different icons come up. So if I try to click on one, it says unavailable. So I keep trying to go to the next one, the next one, and the next one, but they're all the same format, so I can't open any of those.
Okay. And how many times has that happened?
The one time
One
that
file, 10 files, 20 files, 50 files, or was it just the one time and then you moved on to something else?
I don't know how many files were in it because I didn't bother to waste my time on trying to open. I believe I tried to open about 8 or 9 of them, and then I just moved on from that folder into another folder.
And the other items in the other folder, were those accessible? Were those viewable?
For the most part, yes. I have not had a
I don't know
moment
what
to.
for the most part means.
I haven't had time yet to explore everything due to the dorm environment. So as soon as in the amount of information, the vast amount of information that he has on there, I'm trying to.
Dorm environment usually means like maybe they're all staying in the same room, but a lot of times in jails and stuff, you'll have your own separate room, and then you have your day area. So like you can go in your own separate room, pull your door closed, those big heavy doors, you could get your little quiet time in. You got a little desk in there and stuff, sit on your bunk.
figure out a way where I can sit in it. I have a letter to you that I wrote to
We could put her in a suitcase and see how she does inside of a suitcase. Let's do that.
the captain a copy for you. So
Let's
you
try
know what I'm
that.
trying to work on in order for privacy to be had. So I haven't explored both USB drives to the fullest potential that I possibly can.
They call like the jails like with dorms, like you know how there's like open rooms and they're like bunk beds and they're like dorm type. And that's what they kind of call those, consider those.
Yet. Just from the moment that I have attempted to do so, the one problem I have had was with the one folder with many icons in it. I attempted to open about 8 or 9 of them, could not, so I moved on to whatever was next.
About to see what the jail's about.
Hey,
iPad,
I could
home
add to that,
sharing.
everything that we have provided on this
Just
USB
kidding, I'm
file, we have checked. It's all on standard formats. For instance, the public surveillance video that's referenced in our notice, we included both the original Publix files from there, and then we also had those files converted to VLC because they are easier to play in VLC. So if she clicks on that folder, she can click again on a subfolder, and she will find VLC files for where the Publix video has been converted. So everything in there should be standard JPEG, VLC, or I also believe an MP4 or some audio-only files.
All right. Ma'am, do you have any other questions with regard to the digital information or digital evidence identified in the notice that the state's provided the court and yourself this morning?
That was what was just handed to Mr. Lane. So Mr. Lane, you and I would go over that when you and I meet.
I will be meeting with you tomorrow. There is a concern that I will not be able to transfer this to Ms. Boone through the jail protocol.
I have a remedy for that. With regard
There's a remedy.
to, well, let me finish with the digital. Any other concerns, ma'am, as to the items identified in this notice?
Until I'm able to open them and see them, no, I do not.
Sure, okay. State, anything else we need to talk about with regard to that issue?
Not in regards to that issue.
Okay, all right. So, Mr. Lane, I'm going to ask that you take possession of that jump drive that was tendered to you in court this morning, and you advise the court that you are going to be meeting with Ms. Boone tomorrow. Is that correct? About approximately what time are you going to be meeting with her?
I am.
Okay, all right. I have had the opportunity to have further conversations with Major Muhammad at the jail, including conversations regarding the physical documents. Ma'am, are you still requesting hard copies of the documents?
I am.
Okay. The jail has advised me that they've had conversations with you related to any other property or legal documents that you may need. Have you ever advised the jail that you have everything that you need and don't need anything else?
No, one of the sergeants came and spoke to me yesterday, miscommunication of some sort, where I explained to her what I'm trying to do with purging my property in the property department so I can anticipate those discovery hard copies.
Was that Tracy Hall?
No, that was Hall. Her last name is Hall.
So it was Hall, H-A-L-L, correct?
Yes.
Okay.
But someone sent her to me to see me, so I just don't know who that was.
Who was it you communicated with yesterday regarding your personal effects that may have been in a property locker?
Miss Hall.
Okay, all right, thank you. Do you know Miss Hall's first name?
I don't know any of the officers.
Okay, all right. So in conversations with Major Muhammad, they are going to be able to accommodate you having your paper copies. So Mr. Lane, I know that you took custody of those and have had them. So tomorrow, when you meet Ms. Boone at approximately 9 a.m., you will meet Mr. Muhammad as well. Well, let me ask this. Are you able to go to the jail today?
I can.
Okay, so I know for a fact that Major Muhammad is available today, and he may be expecting you to arrive today. If you are able to provide to him the banker's boxes that were identified as A and B and that jump drive, and then provide the court with a notice as to when and what time and that to whom you gave it should be Major Muhammad, those items, so we can file it in the court file. And those will then be, the digital evidence will then be provided with the laptop in accordance with the protocol that we've gone over previously, and Major Muhammad will make sure that Ms. Boone has access to the hard copies. So after conferring, well, let me ask this, State, do you have any other position with regard to the motion that was set to be heard today, the defendant's motion regarding seeking for hard copies?
No.
Okay, so for the record then, that motion will be granted. The motion for defendant to lawfully receive, review, utilize the original hard copy discovery, 2 boxes A and B, submitted to the court by former attorneys on June 28, 2024 for preparation of trial in her criminal case. As ordered, Mr. Lane will deliver those to the jail today and seek to have them delivered to Major Malik Muhammad, along with the digital, the USB drive with the digital evidence. Mr. Lane.
They probably should have gave that to her by now. I thought they already gave her the 2 boxes of evidence. I thought they signed it over and gave it to her, but I guess not. I guess they signed it out and they didn't give it to her yet. I don't know.
The deposition transcripts of detectives Chelsea Copsall and Scott Lowen were reportedly sent to you on August 1st. Did you receive those from Ms. Cashman?
Yes.
Okay, were they a part of the 2 USB drives that we addressed on August 5? You have the smaller one, which was everything you digitized from the 2 boxes, and then you have the larger one of other materials that you've been given previously.
No, but I do have a drive that I can put them on and make sure they get to the jail today.
Okay, if you could make sure, sir, that when you drop off the other 2 things, digital copies, I know Ms. Boone has identified that she has physical copies, but I'd like to give her digital copies just in case. State, do you have any questions with regard to the court's directive to Mr. Lane regarding the hard copies, depositions of the detectives, or the digital evidence the state may seek to admit in trial?
No, Your Honor.
All right. Ma'am, do you have any questions for Mr. Lane regarding those 3 items?
No.
Okay. Can Mr. Lane be released?
Yes.
Okay. If you want to, can he be released, ma'am?
I guess I'll see you at 9.
Okay. Sir, if you could endeavor to do that today, I would greatly appreciate it. All right. Thank you very much, sir.
Thank you.
All right. The next matter this morning
Next up.
is the defendant's motion for defendant's reasonable freedom and movement by allowing her to be unshackled, unhandcuffed, to function equally and comfortably while utilizing the courtroom that was hand filed with the court on August 5, 2024. Court has had the opportunity to review that motion and the law regarding restraints. State, do you have any positions at this time with regard to the defense's motion?
Your Honor, in speaking with courtroom security, we would oppose the motion, and we have Corporal Gavin Lowton available to supplement this court's knowledge on the issue.
Okay, so ma'am, we're going to have a hearing on your motion. The state will call the corporal. He will be inquired by the state as to some concerns that they may have, and you'll be given the opportunity to ask him questions or cross-examine him after the state's concluded asking any questions. Do you have any questions about that process?
Is that today?
That will be happening right now. Yes, ma'am.
Okay.
Do you have any questions about that process?
I don't.
Okay, all right, let's go ahead and call your witness. State.
State will call Gavin Lowton.
That's how you got to do. You just got to shock her with the witnesses. That you don't have no questions.
Please swear or affirm that testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Sir, good morning. Can you state and spell your name for the record for me?
Gavin Alton, Gavin, LWTAN.
All right, thank you. State.
Good golly. How much stuff do these officers have to wear nowadays? I would be falling forward. He's got like a million things strapped to his chest.
You may proceed.
Good morning, sir.
Good morning.
And what is it that you do for a living?
I work for the Orange County Sheriff's Office as a deputy sheriff.
And to what area of the sheriff's office are you assigned?
Court security.
And how long have you worked that assignment?
4 or 5 years now.
And tell us, what are some of your duties within that assignment?
I supervise the deputies in 2 felony courtrooms and 1 civil courtroom.
And are you familiar with the defendant in this particular case?
Just through research that I've done on her, I don't have any personal knowledge.
And what, in regards to that research into the defendant, what is your position as the head of security regarding her request to be free from shackles?
I do not believe she should be free of shackles.
And why is it that you have come to that conclusion?
Based on her current charge, second degree murder, she also has previous domestic arrest for battery by strangulation. She has 3 separate incidents at the jail for non-compliance, where she was told to attend her court hearings or scheduled court hearings, and she refused to do so. And then even when the corrections officers told her she could be charged with contempt of court, she still refused to attend those hearings. Those kind of, when you combine all that, to me it shows propensity for violence and not wanting to follow lawful commands and orders of law enforcement personnel.
What accommodations can be made in order to keep concealed the fact that she is shackled or restrained during trial?
So when the defendant is here, she would just be in leg restraints. She wouldn't have the belly chains. She wouldn't have handcuffs on. We modified the leg restraints by wrapping tape around the chains. So even if she's making motion or movement, it wouldn't make noise to alert the jury as to that she's got restraints on. She would be brought in and sat at the defense table prior to the jury coming in and being seated, so they wouldn't see her walk in with restraints on. And there's a panel in front of the defense table that prevents the jury from seeing that she's got leg restraints on.
Your Honor, I don't believe I have any further questions at this time.
Thank you. Ma'am, do you have any questions for Officer Logan?
I do.
Go ahead.
First off, in your inputs research that you've done on me, the domestic violence case that I was charged with, the felony with strangulation, was dropped. I don't know if you were aware of that in your research. Yes, so I was never charged with that. Also, what 3 hearings is it that I supposedly missed on what dates?
I have those here.
I've never missed a court date. In the almost 5 years that I've been here, I've never argued, I've never hesitated.
Objects to the form of the question, Your Honor.
I'm going to sustain the objection. Ma'am, you have to ask one fact per question.
Okay.
I am prepared to give her the dates. Okay. On September 15, 2023, that was one of the times you refused to attend. October 16, 2023. And January 28, 2021.
And do you know what those were specifically for?
For court attendance, wherever you were scheduled for that day.
For a hearing or pretrial or withdrawal?
I don't know. It was just. This is just information from the jail where the corrections officer said you refused to attend your hearings.
So is that on record that I have supposedly refused these 3 dates
I'm
to
muted.
appear in court?
Jail, yes.
I'm over here complaining about Sarah Boone, and you guys weren't even listening. I didn't even have the mute. I had the mute on, but no, like this guy, it's not his job to know why Sarah was coming to court that day. He just knew I got to go pick up inmate Sarah Boone, bring her upstairs to the courthouse, and drop her off. Like that's all he needs to know. So she's over here saying, I haven't missed a court date. And then he just reads off 3 court dates that she's missed. So, Sarah, you're already caught lying, girl. He waved that paper like, got it. Thank you, Mary Beth, for gifting out memberships. Thank you. That's very kind. Look, we got Fluffy Pink Socks. I think that's a cute name. 11 Summer Moon and Smudge Your Space. Okie Mom and Kathy. Welcome on in, everybody.
Please, I've never missed a date.
This is the database that I got this information from.
Do you know when it was last updated?
I don't know.
Okay, so do you know how I have never missed a court date to the present date? I don't know specifically what these 3 dates are for in order for me to have supposedly denied going. Do you know the name of the officers for each one? You do?
Yes.
Please.
For September 15, 2023, it is Corrections Officer Portia Hines.
Could you spell her last name, please?
Hines.
And you said the date was 9/15/23?
Right.
Okay,
And if you would like, I can read her comments in her report.
sure.
I can read the comments in the report.
Midnight, I informed inmate Boone, Sarah, that she was scheduled to appear in court today. Inmate Boone stated she did not want to attend court. I advised her that her absence could result in being held in contempt of court. Inmate Boone stated she understood and continued in her decision to refuse. Corporal L. Cameron was notified. This report is being generated for informational purposes.
But it doesn't say what it was that I supposedly refused.
To attend court. It doesn't say specifically
To attend
what
court.
your hearings.
Okay,
They went in there, they kicked your bunk, and they said, Boone, you got court tomorrow. And she said, I don't want to go. And he said, well, you could be held in contempt. She said, and the lady, look, I think it was a woman, you could be held in contempt. And Sarah Boone was like, I don't care. And she went back to bed. That's how much she cares.
Second one, it'll be.
Don't interrupt her beauty sleep.
and what is this date for?
I'm sorry, what's that?
October 16th.
Which date is it that you're referencing?
That's going to be October 16, 2023.
Okay, and I'm sorry, the name?
Green, Greene.
And what was the first initial, please?
K.
Greene.
Yes.
10/16/23.
Yes.
Okay,
And the third one is January 28, 2021. And the officer is Jasmine Scribner. Scribner.
what are the comments, please, for Green?
At approximately 0300 hours, I advised inmate Boone, Sarah, that she was on schedule to attend downtown court. Inmate Boone stated she did not want to attend court. I informed inmate Boone that if she failed to attend, she could be held in contempt of court. Inmate Boone acknowledged she understood and continued with the decision to refuse to attend court. Corporal Ward at the Booking and Release Center, transport officer, was notified. All proper notations were made in the IMS.
Okay. And January 28th?
Approximately 03:34 hours, inmate Boone Sarah was advised she has downtown court and to start getting ready. Inmate Boone stated she did not want to attend court. I informed inmate Boone that she could be charged with contempt of court. Inmate Boone still refused to attend court. Corporal Hall and the Booking and Release Center transportation officer were notified of this incident. This report is being generated for informational purposes only.
And all of those comments were made on the day of that I supposedly refused.
I don't know when they entered that.
It doesn't state in their IMS, in their program?
It might, but I didn't take that information out.
Okay, so I'm trying to figure out how I know all three corporals and the sergeant, so I've never refused court. There's no reason for me to want to refuse court.
I'm going to object this to asked and answered.
Unless there's any objection.
So the domestic violence, the original, was dropped. I was never charged with that.
Object as to relevance, Your Honor.
Overruled. You can answer the question, sir.
Okay. It was dropped. You were charged and arrested.
You were charged, but you weren't convicted. Like I said, you were charged.
I don't know why the state dropped it. It could be because both parties, based on the report that I read,
It's because neither of y'all showed up.
did not want to cooperate, so they probably didn't have information to go forward.
Neither of
with
you
the
showed up
charges.
to court.
That does not mean that you didn't commit the act. It just meant the state felt that they didn't have a case that they could win.
What is your definition?
You choked him out and he didn't go to court for you whenever you had to go to court because you was crying, begging, pleading, don't go to court, don't go to court, I'll get in trouble. I can already hear that. I could smell the DV from here, you know?
Probably did not cooperate.
Same
Was
for
it
him.
fact, or you're just guessing?
Your Honor, I'm going to object to the question.
Objection sustained.
She hasn't cried yet though, which I'm surprised. I'd be crying.
Both of the charges were dropped for Mr. Torres and for myself was because we did cooperate and there was not enough information. And we received
Cooperate.
documentation in the mail, both of us, for the reasons why it was dropped.
Your Honor,
The reason why it was dropped, this is what happened. Back in 2018, Sarah and Jorge got in a fight. Per usual. This isn't the first time. This wasn't the last time, obviously. He is walking up the stairs. He's going up the steps. She's going after him on the steps. She chokes him from behind where she scratches his neck, you know, all the things. He turns around and he kicks her in the eyeball with his heel, creates a black eye. So they both get arrested because they both have injuries and they're both blaming each other. Then they both decide not to go to court so that the charges were dropped. Doesn't mean that they didn't do it to each other. It just means they didn't show up and go to court.
I'm going to object this to the form of the question. It's not a question, it's a statement.
Sustained.
Now, if this was Nancy Grace and she was still a prosecutor, she'd say, sorry, I'm taking the charges and I'm running with them anyway. She's done that before. She's told us. Pretty bold.
Forgive me because I don't know what I'm doing. I'm trying to provide my information for what it is that I'm being accused of. I don't know if I'm doing it the wrong way, apparently. So I don't know I don't know the protocol for this. I'm just trying to answer my accusations.
I understand your position. I cannot tell you what to do. I cannot provide you any legal advice.
Okay, I'm just stating to the court that I'm doing my best with being uneducated in this situation. That is for the non-compliance, I need to speak to the corporals and the sergeant in order for that to be remedied. And then what about, do you need the documentation for the domestic charge that I was not charged with and it was dropped cooperatively?
I do know that.
This ain't trial.
I understand, but I was never charged with it, correct?
You were charged with it. It was dropped. The charges were dropped.
But it is not on my record.
The arrest is on your record.
But the charge
Your rep is on your record. You were charged, but he never showed up.
The domestic violence is not on my record.
No, you were never
Object this to asked and answered, Your Honor.
Overruled.
You were never convicted of
Speaking like a true abuser.
And the case was dropped.
Yes.
Seriously, speaking like a true abuser. If this was a man sitting here saying this right now, we would be really fuming, I feel like. She was abusing him. Now, Jorge was probably doing the same to her. I'm not saying that he was doing any better because they both have the charges. But when did you not learn to keep your hands to yourself? Like, did your parents not teach you that? I don't understand it.
Three
I can't ever understand
supposed
that.
non-compliance that I have. I know that 2 of the officers are no longer with the Department of Corrections, Orange County Corrections Department. So I will need to speak to their supervisors in order for me to have, I guess, this remedy. Is it
Your
a,
Honor, I'm going to object to the form of the question. This is a statement question.
Objection is sustained.
I guess I will provide information to you for the non-compliance occurrences that I'm being charged with.
Your Honor, again, I'm going to object as to, that's not a question, it's a statement.
The objection is sustained.
Non-compliant.
I know this is a lame question, but what does sustained mean?
That means the state's legal basis for you asking that question is correct, and the court will not permit you to ask that question
Thank you.
in the way that it may be asked.
You got to reword
What
it.
do I need to provide to you in order to have that remedied, in order for me to be unhandcuffed?
Your Honor, again, I'm going to object as to the form of the question.
Overruled.
I don't get out here today.
Recommendation, but I believe that the decision as to whether or not you'll be in restraints will be made today.
I understand, but it can be made.
What's that?
The decision in order to be unhandcuffed.
Correct. I suppose if you have documentation to say that this was all fabricated, then I wouldn't be able to use this.
Correct, as you telling me about the domestic violence. That cannot be used against me either.
It is still part of your history. I can bring it up.
Right, but just to clarify and
You're
conclude, I was
arrested
not
for it.
ever charged with that.
Again, I'm going to object as to ask.
We're charged. She's killing me, all.
Okay, I will, do I provide this information to you?
You can provide it.
Oh, she refused them, and then the lawyer she had, she fired them. They quit. She called them names. Oh, goodness.
Am I, in your opinion, a flight risk or
Yeah.
detrimental to the courtroom and am a threat of any type of harm?
Based on what I've researched, I don't know you personally, but based on my research, I don't think it would be appropriate for you not to be in restraints.
And then what was the year, please, for the charge that was dropped with the domestic violence?
It was
2018.
2018?
Correct.
And it is now 2020.
Come on now, you know that, girl. I know that. Sarah knows that. Come on.
And you're going
We've
solely
read
off
those.
of, what, the arrest affidavit? What is it that you're using to conclude due to this occurrence that was dropped, that I would not be able to be unrestrained?
Correct. Your arrest history, the information I read, all the research that I've done, that's
Throwing
where I
hands.
based my conclusion on.
But what specifically from that 2018 charge?
The fact that you
You choking
charged
them.
with battery by strangulation, which is a violent act, is one of the reasons why I've said that I do not believe it's appropriate for you not to be in restraints.
But it was never proven, correct, because it was dropped?
It was dropped.
She'll get her table.
Okay.
She's gonna get one. She'll be sitting at that defense table.
I'll be working on the others with the corporals and the sergeant for the supposed non-compliance. Thank you for the dates and the information.
You're welcome.
Ma'am, do you have any other questions?
Do I need to supply anything for the 2018 domestic violence occurrence that you are referencing and applying?
It's already been dropped. I'm just telling you what the history is.
And you can still apply it even though it's not been?
Correct. It's in your history.
Okay. Thank you for the information.
Any follow-up, Steve?
46
No, Your Honor,
now?
it's fine.
Thanks, sir.
46 maybe?
Anything else, Steve?
45, 46?
Okay. I see Deputy Barnett here. Could you come up, sir?
You swear or affirm that testimony you give shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, I do.
Sir, good afternoon, or good morning, rather. Could you state your full name and date of birth for the record for me?
My name is Jeff Barnett.
Not your date of birth. Sorry, could you spell your date of birth?
C-H-A-D-B-A-R-N-E-T-T.
And what are your duties and responsibilities here at the Orange County Courthouse?
I'm Deputy Sheriff of the Orange County Courthouse. I work in courtrooms, I supervise SWATs, and I'm also in charge of training inside the courthouse.
Okay. Is there any training that's addressed with regard to other security measures other than shackles that may be provided for defendants?
Yes, we have an item called a stun cuff that is also used in the courtroom.
Okay, could you step us through what a stun cuff is?
A stun cuff is an electronic device that's wireless. It's box secured to the leg. It has 50,000 volts, and it's able to be remotely sparked from a distance.
How is it fixed or placed on a person?
It's dual strapped along the calf of either leg. It can be hidden in the hands, and gives the ability to be able to walk around.
And who is in charge of operating that device?
It'll be an assigned officer that's been trained in the device.
And step us through the operation of how that device is utilized or operated by that officer.
The officer will show the device to the subject or the inmate or the defendant. It will be secured with 2 straps on the leg. There is a waiver to be signed prior to being used, explaining when it would be used, if it was needed to be used during court, violence, attempt to escape, any actions that lead to that level of to use the device. It's a 2-step process, so there is no way for it to accidentally set off. It has to be hit 2 separate buttons, so there's no accidents. If it had to be used, it would cause a shock to the location on the calf, causing great amount of pain, causing the defendant most likely to fall to the ground, and we could secure and take care of the situation after that.
Are there any other protocols or standard operating procedures regarding the use of the stun belt, other than what you've already identified?
Just to follow the response to resistance policy.
Okay, and can you explain the response to resistance policy?
We have a level of response to resistance depending on what an individual does to what we would do. So if she was attempt to escape or fight, we would use it to match that level of resistance.
What is the level of resistance whereby which the stun belt would be deployed or utilized?
At this moment, it's at a level 3.
And what is a level 3?
3 would be failure to follow directions and stuff like that. If he has to get up and move or not, or follow off order, we could use it. Most likely in the courtroom, we use it probably at a 4 level. That is pretty much fighting, escaping, attacking the person.
Okay, all right. State, do you have any questions to Deputy Barnett?
No, Joe.
Ma'am, do you have any questions for Deputy Barnett?
I do, please.
Go ahead.
Tell me, what is the title of this?
Stun
Cuff.
cuff.
And you said this was applied on the calf or the ankle?
Yeah, the Achilles tendon area of the leg.
And is this something that does it need extensive preparation, or is it something that can just be put on coming and going from the courtroom?
We would place it on you before the court starts. We take it off as court at time. We exit the courtroom. It takes a few moments besides signing the waiver and securing it to the bank.
And it's a one-time waiver?
Each day you have to sign the waiver.
Okay, so there's no limit to how many times it can be put on and taken off, put on, taken off?
No.
And it's a very simple process to apply?
Yes.
And remove?
Just like putting on a belt.
Thank you.
Any follow-up?
Nothing to say.
All right.
Sorry. Would I have my hands free, correct?
Yes, you would have your hands free either way. If you were wearing a leg iron, your hands would be completely free. The stun cuff, same thing.
And then I would be able to walk?
You will be able to walk with the stun cuff freely, yes.
So hands free and able to walk?
Yes.
Thank you.
Any other follow-up, State?
No, Your Honor.
All right. Can Mr. Barnett or Sergeant Barnett be released?
Wonder why she hasn't complained and wants to wear like why is she still in her jail uniform? You know what I mean? Like, I'm surprised she hasn't said she wants to wear regular clothes. The only thing I can think of is nobody will bring her regular clothes to wear.
Yes.
Ma'am, can he be released?
Yes, thank you.
All right, thank you, sir. State, any argument, any further witnesses, evidence, or testimony with regard to the defendant's shackle motion?
No, Your Honor.
Ma'am, do you have any other things that you would like to tell the court with regard to your motion?
Yes.
I don't understand what Sergeant Burnett was that you all providing me an option?
No, you
There
don't get
is
options.
Florida Supreme Court case law addressing reasonable measures for movement by a defendant in the courtroom.
So that is an option.
Yes.
Okay. Do I need to supply the information in regards to the supposed Bree non-compliance before that can actually be made an actual option?
I cannot answer that question because that would be me providing you legal advice as to what you could, can, or should do, and I cannot do that.
Would I be able to be unrestrained with that information?
I think that would come down to the argument of yourself and from the state as to what the local court has to consider with regard to your requests and your motion and what the law is in the state of Florida.
If I may make it clear also, I'm simply just asking to be unhandcuffed so I can write and move properly. I'm not trying to maneuver the courtroom and so on and so forth. I simply just am asking to sit here being unhandcuffed so I can write without taking skin off of my wrist and being extremely uncomfortable.
Okay. Ma'am, thank you for that clarification, because when I read your motion, you asked to be unshackled, to have freedom of movement. And I interpreted that as you wanted to move as everybody else may be able to move in this courtroom, as Mr. Cacciatore has moved
That's
around,
exactly what we
other
read.
persons have moved around. And it wasn't only limited to your hands. I thought it meant to your entire person based on what it is that you were seeking in your motion. So just for the purposes of my own clarification, is your motion only seeking to have your hands not bound so that you can move your hands, but otherwise shackles that may be on your legs would continue to stay there?
Right. I don't currently have shackles, but I don't know what is in regards to trial procedure. And in regards for you not having the clarification of me just wanting to be unhandcuffed, is it my responsibility, or I don't know if you can answer this, but you don't ask questions, which is what got me in this predicament from the get-go of having no counsel, because no questions were ever asked to me. Just for the majority of my motions and letters and so on that I have supplied the court for more information to try to intervene and help, it's just gotten me into hotter water and no counsel and still restrained. So is it something that I need to specifically clarify going forward, or is it something that you have the ability to ask me questions so you have a better understanding?
Generally, I don't know that I can answer that question because it may call for me providing legal advice. If I'm asking questions, it's because I'm trying to clarify things from my understanding. I cannot ask questions on your behalf. I cannot ask questions for you. I cannot assist you in any process, be it this hearing or at trial.
Right. Yes, I understand. I wasn't asking for assistance. I was just trying to understand by you not asking questions in regards to my motion about being unhandcuffed and unshackled simply meant just my handcuffs.
Ma'am, I review your motion to be unshackled, unhandcuffed, and allowed reasonable freedom to move and functioning accordingly, equally, and comfortably while utilizing the courtroom. All normal movement of the defendant's hands is as a whole freely, properly, successfully accomplished any task.
Shook her head, yeah. Shook her head, yeah, because she's like, yeah, I wrote it. I know what it says.
Asking to be unshackled and handcuffed. The defendant is simply requesting equal, comfortable, functional movement to achieve advancement in her forfeited right to counsel by the court, which will greatly enhance the productivity and progress for the defendant and the completion of her defense in her criminal case in preparation for trial. Your wherefore clause specifically asks to be unshackled, unhandcuffed, and allowed reasonably freedom in movement to function equally, accordingly, and comfortably in the courtroom. I took that as you wanted to move around. You did not want to be shackled, which would be your legs as well, and you did not want to have handcuffs. If you're telling me now that all you're asking is your hands to be free, that's respectfully not what your motion says over and over and over again, as I just read. So if you would like to clarify before me now at this time, you can, as to what it is that you're asking of me.
Yes, handcuffed. I would like to have these handcuffs removed from my wrists.
Okay.
In regards to the unshackled, I know at some point I would have to maneuver, I'm guessing, in the courtroom for trial. So I didn't want to have to wait last moment to have to do another motion to be unshackled if that's what my option is, because I don't know. So I was just trying to be transparent prior so you would know what it was that I was hopefully expecting. But first,
go ahead.
It's just handcuffs means unhandcuffed. And if for trial I have to be shackled, to be unshackled.
Okay, and when you say unshackled, what do you mean by that? Just so that we're all in the same field.
Shackled, as far as my understanding is from being shackled, means that I have this along with my waist, along with my ankles. So unhandcuffed is simply for the hands and the wrists, and then unshackled would be for my ankles and for the feet.
And is that what you were seeking for trial purposes?
I didn't know if I was going to be shackled or not. So again, that was why I was trying to be transparent and up forward by doing so now to make the court aware that that would be a request of mine at the time.
Okay, all right. So you would be seeking to be unshackled, no leg restraints, no arm restraints at trial, right?
Please.
Okay.
Yes.
Would you also be asking of the court to move around the courtroom when trial would take place?
I'm not sure if this is considered legal advice, but I don't know. I know from seeing other trials, the state and the defense, they maneuver the courtroom in front of the jury, so on and so forth, and they hand things back and forth. I would have to have other movement other than me sitting here. So yes, I would have very limited, reasonable movement in the courtroom for trial,
Okay.
Yes.
Is there anything else, ma'am, that you would like to tell me with regard to what you're seeking in your motion to be hands-free, for lack of a better word, during any hearings that we may have, and then to be hands-free, unshackled with your legs, and to have movement in the courtroom during the course of the trial? Is there anything else that you'd like to tell me about those requests?
I don't know if you've been able to see my difficulty with just simply trying to take notes. Yes, very much. I would like to be unhandcuffed, just to sit here and be in attendance of my hearings, conferences, whatever it is. For the trial, when the time comes for any limited movement that I would have, the stun cuff, I would sign the waiver now, just whatever it is that I can do in order to enable myself to be able to have the same comfortable atmosphere and movement and equal opportunities just as everyone else.
Thank you. Anything else you'd like to tell me, ma'am?
No, Your Honor.
Okay. State any argument.
Your Honor, you've heard the Sheriff's Office's position. They're in charge of courtroom security. They presented basically their position that she should not be unshackled, but you've also heard from Deputy Barnett who explained the options that are available to the court. Our position is if you do not allow her freedom of movement with the stun cuff, then today is probably the best day to start talking about the logistics of how we're going to do this trial so it does not create the inference that she is an inmate. Does that mean the state will be sitting at a counsel table to question witnesses? How are we going to go about getting back and forth to the clerk and to the witness to present exhibits if she is not going to be able to do the same with shackles? So we just want to bring everything to the court's attention so we can get it all settled today.
I agree, which was the purpose of why we wanted to set it for today, to address all those circumstances and again, think ahead. Ma'am, do you have any closing remarks or arguments that you'd like to make to the court about your desires to be unhandcuffed, unshackled, and or utilize the stun cuff?
I believe that it is unfair that you, number one, want me to represent myself, and then number two, you would like for me to represent myself while being handcuffed to be able to.
No one wanted you to represent yourself. We gave you 8 attorneys.
Progressively and actively participate properly in the same as others with just simply being able to write notes. At some point, I'm sure I will be bringing things with me to court that I need to reach for, to open, to pass normal functions in a body as a whole with the same equal level as anyone in the courtroom would have in order for myself to be able to do the same and function fairly and appropriately. I don't know if this is legal advice or not, but in a trial, are you able to tell me are defendants shackled, or is this something that I don't even need to worry about because they're not even shackled?
Typically, ma'am, the defendants have leg shackles that, as Deputy already identified, Deputy Politan identified, they're wrapped so that they're muffled, so that they don't jingle jangle or bring any noise attention. The privacy panels located in front of defense counsel's table would prohibit the jury from seeing those. Their hands are free, but the legs are in restraints.
Thank you. Yes, I very much would like to be unhandcuffed just to simply take notes and function normally and equally just for hearings and so on and so forth, which we have a lot scheduled futuristically. And then trial comes about. Either way, with trial and or hearings, the stun cuff, I am readily awaiting for that to be an option and to apply as soon as possible. Whatever it is and however it is that I need to, just to at least just have these removed.
Okay, got it. Any closing remarks, Mr. Jay?
No, I just address all the concerns which is the court's plan.
Got it. All right, thank you very much. I think the Florida Supreme Court has given us the guidance specifically for a case just like this in Weaver versus State, 894 Southern 2nd, 178 by the Florida Supreme Court in 2004. In that case, there was a pro se defendant who was representing themselves who had been charged with first-degree murder, and there was no prior history of violent courtroom outbursts. The defendant in that case was representing themselves, and there was some concerns as to being allowed to move around the courtroom during trial may present some safety hazards. The court identified as there would be, in our case, potential sidebars, access to witnesses, evidence, jurors, etc. And that in that case, Weaver's pro se status meant that he would be moving about the courtroom in close proximity to the judge, jurors, prosecutors, witnesses, and potential firearm evidence. This closer proximity to various trial participants arguably raises greater safety concerns than a defendant who is represented by counsel and has no legitimate reason to wander beyond the defense table. Given those circumstances in which a defendant is charged with first-degree murder who is representing himself and moving about the courtroom in close proximity to trial exhibits, especially adverse witnesses, the trial court did not abuse its discretion, even though Weaver had no prior history of violent courtroom behavior. In the Weaver case, the Florida Supreme Court found that the trial court's utilization of a stun belt was not so prejudicial when measured against the other alternative forms of restraint, and whether those alternatives are less prejudicial or viable. There was virtually no alternative to a stun gun, given the visibility of other restraints and the security concerns posed by Weaver's pro se status in that case. It is clear as a matter of Florida law that a criminal defendant's right to be free of physical restraints is not absolute, and that under the circumstances in the Weaver case, the decision to employ a stun belt constitutes a rational exercise of the trial court's discretion that was reasonably necessary to ensure order and safety in the courtroom, especially in light of the defendant's pro se status. In that case, we had a firearm. It was first-degree murder. Here we have second-degree murder. The incidents identified by Officer Politan as to non-compliance in jail for purportedly refusing to return to show up at court, and the charge itself. The charge itself has some level of concern because it is a second-degree murder, but I don't see how where we are right now is not on all fours with Weaver, especially coupled with Ms. Boone's acquiescence to utilizing the stun cuff and saying she'd sign the waiver today. She doesn't have to. You'll have to sign the waiver when we get to trial. So unless I hear anything alternatively from the state, the court's would grant the motion that she would be unhandcuffed for any hearing we have moving forward. Instead of her position in the box, we would probably have her seated at counsel's table, unless I hear an objection from the state as to that. We'll address motions first. State, any position with regard to being unshackled and being seated at counsel's table for any motions moving forward?
No, we defer to the court and the sheriff's office, who's in charge of security. Our concerns are just making sure that she's given a fair trial and fashioning a remedy that is a fair presentation for the jury to observe.
Okay, perfect, thank you. All right, so now the court's gonna grant your motion, and then you will be unhandcuffed for every hearing moving forward. And instead of being in the jury box, you'll be seated at counsel's table, okay? You may still have your leg restraints on, but you'll be hands-free. For the purposes of trial, in accordance with Florida Supreme Court decision in Weaver, you will be hands-free and you will not be shackled with legs. But the stun cuff, as identified by Sergeant Barnett, will be affixed to you and you'll have to sign that waiver. Do you have any questions for me, ma'am?
For sitting here in the counsel's table, you also said that I would be shackled. I'm not shackled now. Will I be shackled then?
My understanding is that you were. If you're not, and the only thing you have is your handcuffs?
Correct.
Is that correct?
Correct.
Okay. If that's the case, then you'll be seated at counsel's table with that, as you are without your hand restraints.
Okay, so I would be unbound.
Correct.
Yes, thank you.
All right. The other item I have on, yes, sir.
I think the sheriff's office is looking for clarification, and I think I am too.
Okay.
I think the situation is because she has handcuffs on now, she doesn't have leg restraints, but for hearings, when her hands are unrestrained, her legs would be restrained.
Okay, I'm getting a thumbs up from the deputy in the back if that's the case. Is that the standard operating procedure, Deputy Logan? Okay, so ma'am, so I'll clarify my order. For the purposes of any hearings, you'll be hands-free, but you will have leg restraints.
Yes.
That's not going to affect any fairness or impartiality because it's just you and me and the state, and no jurors will see that. Yes, sir.
Also, Judge, when she's being transported from the jail, she is going to be fully handcuffed with belly chains and all that. We can take those off.
In advance.
Up here.
Yeah, I agree. I understand that. I'm just worried about the fairness here in the courtroom, especially when we bring in a jury panel. Okay. And for the purposes of trial, ma'am, you'll have no leg restraints, no hand restraints, your hands free, legs free, but you will have the stun cuff affixed to your leg. As identified by Sergeant Barnett, you're going to have to sign that waiver every day, okay?
Of course, and if I may, if anyone knows, the stun cuff, does it go over clothing or does it have to
It is under your clothing, as Sergeant Barnett identified.
Yeah, under.
I have a representative from the Public Defender's Office who I've asked to be here. She's going to have a conversation with you, ma'am, after our hearing, so she can facilitate clothing for you, including pants that would prohibit the jury from viewing that device on your legs.
Yes.
Okay?
Thank you.
All right. Does that clarify for you, State?
Yes, I just saw them and I thought that I saw the confusion based on my experience and how it's done.
Okay.
We cleared it up.
Thank you. Now, ma'am, that doesn't mean that you're going to be able to wander wherever you want in the courtroom. There's going to be spots where you're going to be able to go to. You're not going to be able to walk all the way up to witnesses. You're not going to be able to walk everywhere that you want. There's going to be places that you're going to have to go to. When we get closer to trial, we'll address the box, for lack of a better word, for where you'd be able to go and not go. And I'm going to give the same limitations to the state. Okay?
I understand.
All right. Are you okay with addressing that later, Counselor?
Yeah, I mean, what I would envision is if she needs an exhibit brought to witness, I have no problem getting up and doing that for her.
I was going to, either you could do it or I was going to have the deputies do it. So, ma'am, I envision that because you're going to be able to move about freely and our jurors are not going to know that you have any restraints on you and they're not going to be able to see the stun cuff, you can conduct any questions or statements or arguments from where you would like to be in the courtroom, either at counsel's table or at the podium here for you. If you need to approach a witness or you need to provide evidence to someone, I'm going to ask you and the state to both provide that information or that document to one of the deputies, and they'll be able to approach the witness for you, okay?
Thank you.
All right. Do you have any questions about the court's ruling or the procedures for you having movement throughout the courtroom during the course of our trial?
No, I understand, and you said that it would be clarified greater once we get closer to that date. But I would like to ask, please, when the time does come for any exhibits or anything to be handed to jurors, yourself or anyone in the courtroom, is it an option for the state or a deputy, or is it specifically whoever's the closest and can do it faster?
So what I'm going to do, ma'am, is I've spoken with the sheriff's office. I'm going to endeavor to have additional security in the office or in the courtroom so that there will be a deputy for basically your disposal, be seated closer to you, so that if you have a document that you want to bring to a witness's attention or ask them questions about it, you can hand it to that dedicated deputy for you, ma'am.
Yes, that is my preference, please. Thank you.
That's what I'm endeavoring to try to do for you.
Yes, thank you.
Okay. Any other questions about the ruling?
No, sir.
Okay, so your motion is granted for the reasons stated on the record.
That's called a
Stated
bailiff.
Okay. All right, the last issue that I had on my list this morning was the scheduling order and notice of hearings that the court entered on August 5 required the jail to provide the every Monday at 9 a.m. commencing August 12, 2024, a representative from the Orange County Jail shall email to my judicial assistant, email provided in the order, all notebook entries from IMS from the prior week, Monday through Sunday, for every issuance of the laptop and USB device is issued to the defendant. I'm simply changing that to close of business from 9 a.m. to close of business at 5 p.m. And that order will be hand delivered to Ms. Boone and e-filed to the state today. Okay. Is there anything else, state, that we need to address?
No, Your Honor.
Okay. Ma'am, is there anything else that you'd like to bring to my attention?
Yes, please.
Yes, ma'am.
In regards to the status report you were just speaking about regarding them providing me with a laptop each day, what is your definition of entries?
The protocol, ma'am, that was read to you, that you were given a hard copy of Monday, and was also mailed to you on, I believe, the 30th, at the appropriate PO box for legal mail. The protocol identifies entries that are in the information management system at the jail for when the laptop is released to you and then returned.
Okay, so it's simply just an entry by the officer stating that they gave it to me and it was returned.
I'm making that assumption. I'm just relying on what is in the protocol.
Okay, my concern was they're not stating what it was that I looked at for how long and
I don't know that they're going to record that information on the protocol, ma'am. It's just simply what is checked out and returned under the protocol.
Yes, thank you for that clarification. And then also for the notice of the expected evidence and witnesses at the trial, we didn't discuss the physical evidence. And I know that that was something pending in regards to the media being.
The physical evidence, we're set to review that here in court on September 3rd at 9 o'clock in the morning. And that was identified in the order from the 5th, ma'am, which you said that you got a copy of through the mail. That's in paragraph 5. The state's physical evidence will be reviewed with the state and the defendant on September 3, 2024 at 9 a.m. in courtroom 12A, Orange County Courthouse, and the address of the courthouse. So the physical evidence will be reviewed at that point in time.
Yes, Your Honor, I understand. My question though was, are you still trying to decide or research having the media?
Yes, ma'am. I pulled the case law on it. I need to review that case law to see if an evidentiary hearing is required. I know that we have a hearing that we had set for August 14th, which was to address a couple of other issues, specifically your motion to receive the hard copy documents. We no longer need that hearing on August 14th at 1:30 because the jail has confirmed that they have space and Mr. Lane's taking care of that today. But I do want to utilize that hearing for, I still want to utilize that hearing since we've carved it out. So at that hearing, we can address the media issue based on the court's review of the case law and determine if we have to have an evidentiary hearing, we can have an evidentiary hearing at that time. And also we can utilize that as a status as to your review, ma'am, of the digital evidence and to confirm that you've had the opportunity to review it. You don't have to finalize it, but just to see where you are in reviewing that digital evidence that the state may be seeking to introduce at trial.
This is for the 14th?
That's correct, ma'am.
And what is the time, please?
1:30 in the afternoon.
Okay, and for the case law that you are researching and referencing, are we able to have a copy of it prior?
Sure. I don't see any problems. The Miami Herald decision, I don't know the citation off the top of my head, but I don't have a problem.
I have no problem. I'm familiar with the case.
Sure. Ma'am, what I'll do is I'm going to prepare another order. I'll be able to hand deliver you the one today, changing the Orange County Jail, providing the notebook entries from 9 a.m. to close of business. I can hand deliver that to you today. But in the order that I mail to you, ma'am, it'll provide the case law with regard to the your privacy and media concerns.
Yes, thank you.
And that will be heard on August 14th at 1:30, in addition to a status on the digital. Now, ma'am, based on the scheduling order that will enter back on August 5, you have 14 days from today, absent showing a good
That's probably exactly what they put on Brian Kohlberger because they have to have something on him.
cause
you
to
know?
extend any deadlines to provide your objections in writing to that evidence.
I'd never heard of it before.
Objections for the
The
evidence from
digital
the state
evidence. The digital evidence only.
of the 2 USB drives from Mr. Lane?
No, ma'am. The USB drive that Mr. Lane's going to be providing to the jail today that has those 9 items
Oh, yes.
as identified in this notice of expected evidence that you were provided today.
14 days and I have to write objections?
That is correct. So your objections to the digital discovery will be due no later than August 23rd.
And just think you had 8 people that were willing to help you fight. And you called them buffoons and they didn't know what they were doing and all the things.
And I will put this all in
All the
order
things.
for you as well, ma'am.
Thank you.
I believe
Now
that
you're gonna change your
addresses
mind.
all of the court's matters that were teed up for today. State, do you have anything else?
No, Your Honor.
Ma'am, is there anything else?
Just when you think she doesn't have something else, she's gonna Ann Taylor it on you, and here she goes.
I do have this. I made a copy of it for you. This letter that I supplied to Captain Di Giovanni upon her return, knowing what I'm requesting. I don't know if I'm able to tell you, but it is a basic laptop. I have no internet and I have no phone. I'm trying to utilize the classroom that is in our dorm. I'm trying to have access to a phone. The USB drives, how they're being handled, I feel very uncomfortable with, as I referenced to you prior. They're being taken out of the bags, and then paperwork is being removed from those bags, like the protocol security paperwork that I needed to reference, and then they're resealing the bags. The other day, one of the officers took the USB drives upon herself to remove from the bags herself, and then just handed me both the USB drives. I don't know where they go. I don't know who controls them. I don't know how they're stored. And one of my requests was to keep it at my bunk in my locked drawer. Along with, of course, the internet, if I could be supplied earphones and headphones for listening, and a word program, just simply to be able to type motions and letters and anything that needs to be documented or recorded. It is simply a basic laptop in order for me to view my USB drives, and just, as I stated earlier to you, some of the parts of the USB drives cannot be viewed, which I will discuss with Mr. Lane tomorrow when I visit with him.
Ma'am, well, you could give your letter to the deputy. We will file that in the court file. Part of the reason we had set the August 14th hearing on your motion for the hard copy discovery was that Captain Di Giovanni was returning on August the 12th from a vacation, and we were endeavoring to have a representative from jail or herself be here for that hearing. So in addition to a status as to your review of the digital evidence, a hearing on media request or prevent media from being at the September 3rd discovery viewing hearing will address your concerns as identified in this letter and have a representative from the jail, be it Captain Di Giovanni or someone else, here to address those concerns.
Thank you. And if I may say one last thing, please, in regards to the media being a part of my discovery hearing, I am highly opposed to it.
What are you highly opposed to?
That is, I know that I have a lot of my case details that are already online. For me to be recorded, inspecting and testing and photographing, I believe that is my business only, and one privacy that I should be able to maintain, especially being in the courtroom doing so.
You're talking about the September 3rd evidence, right?
For the media?
Correct.
Correct.
Okay. Again, ma'am, we're going to have that hearing on the 14th.
Thank you.
Okay. All right. Any other questions, ma'am?
No.
Okay. I will see you all on August 14th at 1:30. Oh, thank you. Ma'am, as the attorney from the Justice Administration Commission had identified, he has provided the court via email the pro se packet. I have a hard copy for you, and I'm going to have Ms. Berrios also send you a copy by way of the mail. It was already mailed.
Getting all the copies.
Okay, we're going to mail you a copy as well, ma'am. Today, I'm going to give this to the deputy to provide to you. This is the pro se packet that the JAC attorney made reference to on our hearing on August 5.
Yes, thank you. And then also the public defender's office, you said, would be meeting me downstairs?
They're going to be meeting you momentarily. Be that right here or downstairs, I'm not sure. But they will be meeting you to discuss that. Okay, thank you, Ms. Click. All right, any other questions, Dave?
No, Your Honor.
Any other questions, ma'am?
No, Your Honor.
All right, we'll see you on August 4th.
She is nice. She is nice when she says, you know, Your Honor and all that, but not intentional, right? Yes, they keep me not intentional. But it was not intentional. But it wasn't my intention. If we were drinking during that, and I don't even know if that was an interview or if that was an interrogation. I don't know what that was we watched that day. We would have all been drunk within the first 5 minutes of that. We'd have been sloshed. We'd have been so drunk. She kept saying, but that's not my intention. It's not intentional. I'm like, it probably wasn't intentional when you put him in the suitcase, but when you walked away and then you started recording and then you threw his shoes at the suitcase while he, like when he's unalived in there, just tossed his shoes over to him like he's nothing, like he meant nothing to you. Oh man, that gotta hurt. They were together for a long time. I mean, not like, you know, a long time, but I mean, for years. It's crazy. It's so crazy. Yeah, where are we going? Why is everyone buying liquor and stuff? Watch party? An inmate who hasn't got a clue about pro se wouldn't know. Yeah, very least about typing motions. I think that I think she's copying her motions and her way of writing off of other people's work too. Do you know what I mean? Like other court documents that she's gotten. Because there's no way that she wrote that court document. I mean, it was pretty good. Like it was pretty like spot on to what they usually say in the court document. So, oh, thank you for ordering it. I'll send it out tomorrow. Thank you. I appreciate that. It's going to look cute on you. I'll take a picture and send it to me. Well, you guys are going to have a good time somewhere. Where's everyone going, sirs? You guys live all the way on the other side of the country. Why can't you guys be a little closer over here? Utah, Idaho, Arizona. We got people in Texas. We got people in California, Oklahoma. West is from Oklahoma. Yeah, everybody's like West. I mean, we got some people on the East Coast too, but you know, a lot of our people are on the West Coast, seems like. Or, you know, middle or West. She does have nice handwriting. She does. And she's being really, I mean, she's being nice to the judge. She's asking a lot of questions, which I mean, she's asking legit questions, you know, like about the cuff thing being on her leg. She's like, is that like, how does that procedure work? Is it like hard to do? I think those are more like, I think she's asking those type of questions because she's like scared of if it's going to hurt. Like she can't ask them that. Is it, if you have to like, you know, buzz me with it, is it going to hurt? Like she doesn't want to ask that. So she asks like in a different way. So. Your house for sale in Tennessee? I want to go to Tennessee so bad. I just want to go into Gatlinburg. I've heard that it's beautiful there. I heard a lot of people go there like as a touristy place. But it's good, I heard, for like a lot of couples to go. And so the judge is so patient. Yes, very patient, but very to the point at the same time. Do you know what I mean? Like we're okay, like we got that addressed. We're moving on. Like Judge John Judge in the Idaho case, that guy can't make a decision to save the case. Like he'll make a decision after court is done. You know, like he'll put it in writing weeks later and we'll get it. This judge is like, nope, we're going to set these 3 hearings today and we're doing them all. And he did them. I was like, wow. But I do have a bunch of other things I want to go over with you guys. And for this case and other cases, we've got a lot of stuff to cover. I have like a lot of open tabs because there's just like new things coming out. We're still doing Delphi. We were going back with the first 2. We listened to the 2 podcasts that were kind of like getting us caught up with the beginning of the case and refreshing our memory, because we're trying to refresh our memory because trial is going to be starting soon. And it's like, it's a crazy case. If you're following it, it's really, really, really crazy. So we're starting at the beginning. That way, if anyone wants to hop on board and start fresh with us, you can. We did do 2 podcasts. They're available on the playlist. And we've read through all the documents and stuff before, but we're going to redo all of that stuff. Also, Nancy Grace did another episode. So she did one that we watched like last week. And then 2 days later, she did another one. And I was like, really? Another one? So I wanted to show you guys that. And then there was a couple other podcasts for and videos for the Delphi case to get us caught up. What else? There's something going on with Suzanne Morphy, but I'm not sure. Oh, Barry Morphy's now suing officials for violating his rights. Is that all we're going to hear about? Never mind. That might not have been a good update, but if it's a better update, we'll go over that. If not, maybe we'll just go over it anyway. Keep her case alive. Keep her name out there. And then I have a podcast I was going to play for you guys for Idaho. We got a lot of stuff going on over here. So if you're into any of those cases, make sure you subscribe to the channel. If you're over on Unfiltered, I almost said Uninvited. Whose channel is Uninvited? Is there someone's channel that's called Uninvited? Because that sounds like a good channel name. I think I want to change my name now. Unfiltered is my other channel. Yeah, we do. We cover Suzanne here, but yeah, we'll have to cover her case and do like an update. It's been a while since we've done an update on her case. Since they found her. That was the last time we had done anything. So we have that. We have Idaho, Delphi, Crystal Rogers cases. There's stuff going on in that. I need to look up about Veronica and Jillian Kelly, Veronica Butler. I need to look into their case. I need to see what's going on with the God's Misfits. See if they've been in court. I know a lot of them are getting ready to coming up on court dates, but as of right now, they don't have any. And I think that's about it. But I do have some stuff. Also, I put on a regular video. I did a regular video, just the interview with the Gonzalez family. If you didn't watch it last night with us, it's just the video of the interview, so you don't have to like watch the whole live. Alanis Morissette. I love Alanis Morissette. Actually, where was that? I was singing her the other day. And I was just singing, it was just around the house. And you know something about Alanis? I was in like 4th grade when her CD came out, right? I was in 4th grade. It was either 4th through 6th. It was 4th through 6th grade because I went to the school I went to, and I would swing on this swing during recess. And I'd be swinging away. Just imagine a little me, because I look the same, just little. And little me. And I would be singing her songs. And I don't think I had the words right. I mean, I'm sure I probably didn't. But now looking back on it, you listen to that CD and you're like, what the hell is my mom letting me listen to? But it's pretty funny. It's just funny how like we listen to songs when we're younger, we don't even think about it. And then when you get older, you listen to the same songs and you're like, they just hit a little differently. You're like, wait a minute here. Really? You went and saw her last month? I bet that was fun. See, I would go see her in concert. Oh yeah. All day long I would. I bet that was a good concert. I didn't know she still performed. Shoot. Get on over to Ohio. We'll welcome you here. We'll welcome you here. I live like I don't know, one exit away from Dave Chappelle. We got people here. We got a funny guy. That's all we got. We don't have anybody else that's famous, I don't think. JD Vance, but he's not really famous. He's trying to be. Oh, that will be fun. You're taking your 34-year-old daughter to see Avril Lavigne this month. Oh, the 20th this month. She's going to love that. That's like the best time to go to a concert, I feel like, with your daughter too. You know, that's going to be fun. I miss those times with my mom. I wish she was still here. I wish having like those little, like, you know, just the little things that you can like tell your mom when you get older, you know, when things are hurting, things aren't working the way they should be. And with me, it's all metal. So it's like, what the hell's going on? So what in the name of the newest Idaho case? Idaho 2 at 2.0. Oh, I don't know. Who knows? Alanis would be a great one to see. Oh, Chad Dorman. Did you guys see his picture? I put it on the community page. Well, he looks more like an inmate now. Let me go to my tab and I'll show you. If you guys didn't see it. If you don't ever check the community tab, make sure you check the community tab. Sometimes I post on there. I usually post on there every once in a while. Where was it? Oh, right here. Yeah, there he is. Shaved his head, got him all ready, you know. I said, getting all ready for his new home with his new family, POS. And then that's just, he's in Columbus. He's just in the reception center right now. So I don't know where they're shipping him off to. He could be there for, I think, a week or two. And then they'll ship him off to his forever home. Pray. Everybody pray a little prayer. I hope you go to Lucasville. I hope you go to Lucasville. It's the toughest maximum prison in Ohio, and they will not take kindly to you, sir. I hope you go to Lucasville. They better lock you up in segregation. Yeah. I don't ever want to see his face again. After I exit off of this, we're over him. We're done. We're done with him. Unless, you know, he does something stupid and we got to cover it. Or something good happens and, you know, we hear something good with Laura or her daughter. But man, I don't like that guy. New Kids on the Block. That's fun, Mary Beth. Shoot, I'd go to that. I had the New Kids on the Block. I think I had a pillowcase or something. I love New Kids on the Block. I was into New Kids. Yeah, definitely was. Definitely was. I liked I liked Mariah Carey a lot. Now that girl, almost 90s Mariah Carey, I liked her. 80s, 90s Mariah Carey. When I was like really young. I used to listen to a lot of country too. Yep, Durham is nothing but a number now. Yep. And I hope that, I truly hope that brings Laura and her daughter just a little bit of, if anything, just a little peace, knowing that he looks like that and he's Bye, out of your life forever. And they do have a GoFundMe. Let me grab that for you guys. Let me see if I can find it. Like they have so many people that's helped them. Like they're going to need every single cent that these people can get, you know? I mean, they're rebuilding their whole life, but they have raised, their goal was $20,000 and they have raised $284,226. And they are going to need all of it. And none of that money will bring her babies back. You know what I mean? That I know any mom in here would give that money to have one kid back. You know what I mean? Like, it's just so sad. So sad. It's just I'm mad. I'm mad in a way that like he didn't go to trial because I wanted to be there and I wanted to see him in person, but I'm glad because of his family. But I wish they wouldn't have had that surprise hearing. I wish we would have known about it and they would have scheduled that, you know, hearing where he went in and he pled guilty. So that way we could have, you know, had a chance to go down there and record it, just because I do live so close. I live an hour from there. So, but yeah, it saved them from having to testify. And we read their victims' impact statement and then we heard them and yeah, it's bad. People are so just be good to each other. It's not that hard. It's not that hard. Stay in your own lane. Do we need to start like 6 foot distancing again? Just think about that. Sarah Boone has not been out of jail since before COVID. Wow. That's a long time, Sarah Boone. But thank you guys for being here tonight. I'll be back tomorrow with a live. Maybe I'll do like a poll and you guys can pick whatever we go over tomorrow night because we have a lot of stuff we can go over. Also, have a good weekend if I don't see you tomorrow. If you're going to be out and about doing things with your family, have a good day and have a wonderful day. Bye, guys. See you tomorrow.